Hi, my name is Anya Prince, and I'm an associate professor at the University of Iowa College of Law. Today, I'm going to talk to you a bit about an intro to important legal cases in genetics. So I have no conflicts of interest to disclose. So let's get started. Uh, the law is so important in genetics for a lot of reasons because when you're giving clinical care or doing research, law creates the background of the rules that are in place. But genetics is really testing a lot of our traditional legal rules, whether it's in malpractice or in responsibility that researchers and physicians have to their patients or genetic counselors. And so I'm going to go through some of the highlights of some of the laws that have been important in genetics, some of the legal cases, I should say. I just want to talk a little bit about precedents. In law, if a case is at the US Supreme Court and it's about federal law, then it sets precedent for the rest of the country, right? It sets precedent for the entire federal system. But if it's a lower court case, then it only sets precedents and it only holds within that jurisdiction. So a lot of times you'll hear about interesting legal cases that are published or talked about in the news that make it sound like it's really important for the country, but actually might not have that much power, right, or set that much legal precedent outside of the jurisdiction. And so throughout the day today, I'll try to note where the cases are coming from. Now, I should say that because genetic cases are so rare or new, right, courts from another jurisdiction can look to other cases, right? So they can borrow from another area or another jurisdiction and say, oh, that's an interesting way to interpret this problem that we haven't seen. We'll borrow that, right? And so we've seen cases that started in one jurisdiction that kind of become the norm across the country. But that's not necessarily the case. And so it's always important when looking at laws and looking at case law specifically to look at what jurisdiction it's in and to not hear your friend from another state say, oh, there's this new law or there's this new case, and so therefore this is the new rule in genetics, because that might not apply across the board. And then as you all know, as genetic counselors, when you give presentations, you're not giving individualized medical advice to people. And in that same way, I am not giving any legal advice today. And if you do have any questions about your own responsibilities or your patient's responsibilities or liability, then you should have them speak to a lawyer or speak to a lawyer yourself. But I really want to give an overview today of some of the interesting and fun cases that come up in genetics. So I'm going to talk about 5 themes, and we don't have that much time. So this is going to be a very cursory introduction into some of the laws in these areas. So I'm going to very briefly talk about ownership of biospecimens and genetic data. I'm going to talk about liability. I'm going to talk about duty to warn, which is connected a bit to liability. And then given some of the recent news about the Golden State Killer, I'll talk a little bit about criminal law, and then I'll talk about genetic discrimination. Now, I should say that this is being recorded in August of 2018, and so laws change, court cases change, and so make sure that you're paying attention to when you're listening to this, and that the legal landscape may have changed if you're listening to this at a future date. All right, so let's talk a little bit about ownership and what case law has said about ownership. One of the most famous cases in this area is Moore v. Regents of the University of California. This was a case out of the California Supreme Court back in 1990. So the facts of this case are that there was a patient undergoing treatment for hairy cell leukemia. And unbeknownst to him, when he got a splenectomy, the doctor and a researcher coordinated to give the researcher part of the spleen. So Moore didn't know this. He knew he needed that surgery, but he didn't realize that there's going to be a researcher that was collaborating with this doctor. Eventually, the physician and the researcher together applied for a patent on the cell line that they created from this patient's cells. So the patient brought several different claims, and one of them is conversion. Right? And this is just a legal claim that says you took my property and used it for something else that you didn't have permission. And so he argued that he retained an ownership interest in his cells. Right? So he said, I had a property interest or an ownership interest in my cells. You took those cells and you converted it into this patent, which gave you money. And so I should have been either asked permission or have part of that money. So for that specific conversion claim, the court held that the patient does not have a property interest in their own cell lines. Right? So there were other claims that he could have continued forward with, but we're just talking about the conversion claim. So more the patient lost on that claim. And the court said, no, there's not an interest in those cell lines. Once that spleen is removed, then you don't have a property interest. And if somebody uses that spleen or any of the cells from it to continue forward and make money off of it through a patent, then you don't have a claim to that. Now, this is one of those cases where, although it's just, the California Supreme Court, so it only applies to the jurisdiction of California and California state law, it really did set the norm across the country. And so in general, that's the lay of the land, where people don't have a property interest in their cell lines, although there are some states that have laws that say that you do have a property interest in your genetic information. And so it can vary state to state. Another case surrounding ownership is Greenberg v. Miami Children's Hospital. This was a case out of the Southern District of Florida, so not just within Florida, but a specific jurisdiction within Florida, the Southern District. Right? And this happened back in 2003. The facts of this case are that there was a patient group who were advocates for Canavan's disease. And that patient group helped researchers with tissue donations, financial support, and they assisted the researchers that they were working with or collaborating with. They assisted them in finding families to recruit for further research. So they really did a lot to help these researchers get access to the patient community for the rare disease of Canavan's disease, right? So that the researchers actually had enough data to do the research. Then the researchers applied for a patent without the patient's knowledge. And the patients were upset partly because they wanted this to be accessible to as many people as possible. They were interested in sort of crowdsourcing, getting all of their community together to help build treatments, options, and they didn't want a patent to narrow that, right, and somebody to make money off of it. And so they had lots of different claims, but they all had that same one that was brought by Moore, and so they said that this was conversion, right? So they took my property and they converted it to money, right? And the court held that this was not conversion, since the information and the samples that were given were donations. So if I donated money to a charity and then they took that and raised more money, I couldn't say, oh, I have interest in that new money, or let's say they invested it, right? Because I donated the money, so it's no longer mine. In the same way, the court compared. They said property once voluntarily given, you no longer retain a property interest in that, right? So if I give somebody, if I donate my car, I no longer have a property interest in it. If I donate my cell samples, my tissue samples, I no longer have a property interest in it. And so similar to the holding in Moore, there was this general view that people don't have a property interest in their physical tissue, right? And this has a lot of implications for research overall, because we do a lot of research with biobanks on tissue samples and different biospecimens. And so this has really shaped research in the community. A third case is Perlmutter v. Perenboom. I have no idea if I'm saying those names right, so apologies if I'm not. So this is a pending case in Florida. And this is a really interesting soap opera-y type case. And it involves a neighborhood dispute over tennis courts in a very fancy neighborhood in Florida. This eventually got so heated that it led to hate mail being sent to one of the parties' homes. That was one of the parties in this dispute. So that person who started getting the hate mail, he and his lawyer got DNA samples from 2 of the neighbors to compare those samples to the licked envelopes of the hate mail. So they essentially called in the neighbors who they suspected of sending this hate mail. They gave them water, and then they surreptitiously collected the DNA off the water bottle, and then they wanted to test it to say, look, these are the people who actually licked the envelopes, and then we can tie them to the hate mail and all of that. So the neighbors who had their DNA surreptitiously taken, they did what's called countersuing, right? So they said, well, you're suing us for this hate mail. We're going to make a counterclaim that said that there was a conversion of property, that you took our DNA off these water bottles. And so the original person filed what's called a motion to dismiss. And this just means that claim can't even go forward. We shouldn't even argue it because it doesn't rise, it's not meritorious enough to even meet the legal requirements. And the judge declined this motion to dismiss. So what that means is the claim can go forward. And so this means that there could be the possibility that taking this water bottle and taking the DNA from the water bottle is conversion, right? That case hasn't been settled yet. It hasn't been decided yet, but it leaves open that possible argument. And so here's a quote from an article that helps to describe this. So Perenboom filed a motion to dismiss, in all likelihood fully expecting the motion to be granted. To argue that something has been stolen, you must first have to make the case that you owned it in the first place. And in the past, courts have generally held that samples of your biological material are not something you own. Right? So that's the end of the quote, and you can see from Greenberg and from Moore how courts have generally held that you don't own biological material. But by leaving the door open to make the claim of conversion in this case, the judge is hinting that this family, these neighbors, may have had a property interest in their biological material. So we'll watch this going forward and see whether this changes the way we think about access and property interest in one's information. Another interesting piece of this case is it's talking in some ways about the genetic information that came from this sample as opposed to a tissue sample, right? And so that can be an interesting legal differentiation where there's a difference between whether or not you have a property interest in your actual tissue samples versus having some sort of property or privacy interest in the information that comes from those samples. And so that's something to keep an eye out in the future as this case goes forward to see whether the law changes and whether it changes just for the information side. So ownership is an area that has definitely been talked about a lot, and that's sort of where we're at watching these cases. Another big area, of course, is liability. Now, there's lots of different case laws about liability. There's cases about medical malpractice in all sorts of genetics arenas, from prenatal testing to cancer diagnostics. But I want to talk about 2 types of liability that I think are brought out less often than sort of our quote normal medical liability. And that is researcher liability and laboratory liability. Now, in general, liability is modeled after medical malpractice, and medical malpractice is modeled off of our negligence law, right? So whether or not somebody is negligent. And in order for there to be medical malpractice, there has to be a duty. there has to be a breach of that duty. There has to be some causation. So that breach of the duty caused the patient some harm, and there has to be damages. So in a typical medical malpractice claim, there's a physician-patient relationship. So that relationship creates the duty of the physician. Maybe the physician doesn't do the proper analysis of a test result. That's the breach. If that proper analysis, maybe they failed to diagnose a tumor. Right, so that's the breach of the duty, and that caused the tumor to grow when the patient could have started chemotherapy early, and then that caused damages, right? And by damages, we mean monetary damages in the legal system, but it could also be like pain and suffering and those sort of things, right? So that's the general medical malpractice framework. So the question is, if we think about researchers and we think about laboratories, what is their duty, right? If we think about that first prong of this test, what we call it in law, if we think about that first prong, the duty prong, what does that look like for researchers and laboratories? So there's two cases I want to highlight for this. So one is Andy v. Rock. And this talks about researcher liability. This was a Wisconsin Court of Appeals case in 2002. So again, think of that jurisdiction and how this might apply in other jurisdictions, right? It doesn't hold precedence everywhere. But the facts of this case were that there were researchers conducting a cystic fibrosis study where they used the excess blood from a newborn screening panel. All the samples were tested for cystic fibrosis, but parents and the families were split into two study arms. Half were told if the child was positive and were given a nutritional information plan, and half were the blinded controls who were not told about the positive results. And so half the families wouldn't have known what the results of this cystic fibrosis test was. So the Andys were a family who were having a kid, and they were given a pamphlet about the research, but there was no specific consent. So they didn't go through an informed consent process. And they happened to be placed in the control arm, meaning they weren't given information about the CF diagnosis if there was one. At 2, their child was diagnosed with cystic fibrosis after showing some clinical signs. And at that time, they were also pregnant with a second child who was also later diagnosed with cystic fibrosis. So the Andys found out that this research protocol had been going on, and if they had known, right, if they had gotten that result, they would have found out that their child had cystic fibrosis. They may have been able to intervene earlier than 2, and they might not have decided to have a second child, or they may have decided to do pre-implantation genetic diagnostics or something like that. So they had several claims against the researchers, but we'll focus on the liability claim. And that claim argued that the test results were withheld, and this prevented them from mitigating the severity of the disease and prevented them from making those family planning choices. And so that the researchers should be liable for causing those damages, right? So we have that causation and damages. But the question is, what was the duty? And the court held that the researchers did not have a physician-patient relationship with the parents, and therefore this did not rise to a medical malpractice claim. And because there's not that heightened duty, right, there still sometimes in these situations could be a general negligence claim, but the rules and the norms in medical malpractice is higher, right? So there's a higher bar that somebody has to meet when they have a heightened duty. And so because the researchers did not have this heightened duty, then the court said they couldn't bring this medical malpractice claim. So what about in the laboratory setting? So Williams v. Quest is an ongoing case about laboratory liability. This is in South Carolina, I believe. So the facts of this case was that Williams had a son who was born in 2005, and he started having seizures about 4 months old. The doctors suspected that he had Dravet syndrome, and so he got genetic testing done in 2007, which came back as a variant of uncertain significance, or VUS. So the doctors then treated him with sodium channel because they had changed their diagnosis from Dravet syndrome to a mitochondrial disorder after the VUS. But the treatment of Dravet is to avoid sodium channel blocking medications because they exacerbate symptoms. Right? So eventually, unfortunately, the child died from the seizure disorder. And so the mother, Williams, was investigating this. And in 2014, 7 years after her original report, she asked to get access to that report. And in 2015, Quest issued a revised report that listed the variant as a known disease-associated mutation. So they listed it as a pathogenic mutation and reclassified it, although there wasn't any new evidence in the medical literature that they cited to for changing this classification. So the mother sued for medical malpractice, or she sued for negligence, my apologies. She sued for negligence, saying that this caused her child's, it caused them to have a treatment for the child that was incorrect for his diagnosis, and that if she had been given the correct information, they could have properly medicated him and they could have avoided having him pass away. What's interesting is that Quest, the medical laboratory, the laboratory that did the genetic testing, they actually argued that this was a medical malpractice claim. So the question becomes, is a laboratory providing medical care? Is the laboratory a healthcare provider when they're analyzing somebody's genetic sequence? Now, on the one hand, we might think that Quest doesn't want to have to rise to those standards of being a healthcare provider because there's heightened duty that comes with it, right? But in law, a medical malpractice claim in this particular jurisdiction, and this is common across the country, that the medical malpractice claim has a shorter time frame in which one can bring a case, right? So there's a thing called the statute of limitations, and that limits the time frame that somebody can bring a case against somebody. So somebody can't bring a case, 50 years after the event happened because the witnesses may have passed away, the evidence is difficult to procure. And so just for fairness, we have these rules of statutes and limitations. And in this particular jurisdiction, the medical malpractice claim was shorter than the general liability claim. And so the laboratory was arguing that they are providing healthcare services in order to foreclose Williams from even bringing the case in the first place. And so the judge in this case asked a question to the state Supreme Court, right? So they didn't look into the case too much. They just said, before we figure this out, we need to see what the state Supreme Court says about laboratories as healthcare providers. And so in July of this year, in July 2018, the state Supreme Court said that Quest was acting as a healthcare provider. And so that then pushes the action back down to the lower court where they'll go through this case, right? And it could be that now the case is dismissed if the lower court judge says, yeah, they were acting as a healthcare provider and you took too long to bring this case, and so you can't bring the medical malpractice case. There's some room for wiggle room and some appeals, and so this case is still ongoing, but it's a really interesting precedent to set. Granted, it's going to be at the state level, and so it won't necessarily be across the country, but it's a first in its kind case that really looks at what role laboratories are playing and if we should consider them healthcare providers. On the one hand, they are interpreting medical information and they are sending that information which has an effect on somebody's diagnosis and treatment back to the patient. On the other, they don't have face-to-face interaction with the patients. They don't, and so they're a little bit different than the physician. And in many cases, that result that they're interpreting is mediated by a genetic counselor or by a physician who's the healthcare provider. And so this case really could go either way, but in South Carolina, they said that the laboratory was a healthcare provider. So this is definitely an area where I think there'll be more litigation in many different jurisdictions going forward, and something to keep an eye out. So a related topic to liability in general are these duty to warn cases. So duty to warn is whether or not healthcare providers have a duty to warn third parties about medical information, right? So in general, we have rules that say that you can't break confidence, and we have laws that say that medical information is private. But are there cases where information should be shared in order to protect somebody? And the most famous case that sort of started these whole duty to warn cases is Tarasoff v. Regents of the University of California. This was a California Supreme Court case way back in 1976. This was not a genetics-related case. It was a psychotherapist. And this California Supreme Court said that a psychotherapist had a duty to warn a foreseeable victim of a threat. In that case, the psychotherapist patient had indicated that he was going to attack this third party, and he had threatened to kill the victim, and actually eventually did kill this person. And so the Supreme Court said the threat was such a serious danger of violence that psychotherapist should have broken confidentiality and warned this person that they were being threatened and that their life was being threatened. So that's the sort of idea that came out in this 1976 case. But this idea of duty to warn has then moved into the genetics arena. Now, this is in the genetics arena, right? The question is, should a healthcare provider provide the family members information about a patient's hereditary information if it might save their life? Right? So that's a little bit different than a threat to kill, right? It could be a little bit, depending on the penetrance or the nature of the condition, it might be a little bit more tenuous of a relationship between the information and the threat than a threat to have a patient kill somebody. And so let's look at two of the famous cases in this. Now, this is an area where I really want to note the precedents, because these two cases that I'm going to talk about are cited all over the place as creating this duty to warn, right? But these are not broad cases. They aren't US Supreme Court cases. And so this is one where in most jurisdictions, there really is still an open question of what the responsibility of healthcare providers in this arena are. So Pate v. Threkel. So the question in Pate v. Threkel was, does a physician owe a duty of care to the children of a patient to warn the patient of a genetically transferable nature of the condition for which the physician is treating the patient? You gotta love legal language and legal writing. So what are the facts of this case? So the patient had medullary thyroid carcinoma, an autosomal dominant type of cancer. And the mother was not told of the hereditary nature of the disease. The patient was the father, right? So the mother was not told the hereditary nature of the disease, and one of the daughters got sick. I'm pretty sure that the father had passed away, and so that's why it's a question of whether the mother should have been told. And so a medical malpractice claim was brought, arguing that if the daughter was warned, she could have prevented the cancer. And so what the Florida Supreme Court held was that there was a duty to warn when a, quote, reasonably prudent physician would also give such a warning. But they said that telling the patient about the heritability risk satisfied that duty. So if the doctor had told the patient, hey, you have this type of cancer, and by the way, that means that your family members are also at risk, then that would satisfy the duty to warn. And it doesn't matter whether or not that family member then went on to go and tell his family, right? And so the duty to warn is satisfied as soon as you tell the patient about it. In contrast, just a year later, a case called Safer v. Pack was decided. This was a New Jersey Superior Court Appellate Division, so not even the statewide, a smaller jurisdiction. But the facts of this case was the doctor was treating a father in the 1950s and 1960s for colon cancer, and the father died in 1964 when the daughters were 10 and 17, right? So if you think about that time span, this was many years ago, right? And in 1990, so many years later, the daughter was treated for colon cancer, and that daughter brought a claim of failure of duty to warn. So the lower court dismissed the case because there was no legal duty to warn the child, as no physician-patient relationship existed, right? So the lower court said the patient-physician relationship was the doctor and the father, and so the doctor had a duty to the father, but the doctor did not have a duty to the daughter. But this appeals court said that the duty extended from the patient to members of the immediate family of the patient who may be adversely affected by a breach of that duty. And so they said that the duty to warn of an avertible risk, right, so something that could be prevented, is sufficiently narrow so we don't have to worry about a strain on the system. So a couple of notes on their interpretation, right? They talked about immediate family members, and they talked about avertible risks. And so this doesn't necessarily mean that the precedent in this jurisdiction says that people have to warn about all genetic conditions, no matter what the penetrance, no matter what the family member relationship is, or no matter what the prevention available is. But in this case, it seems from the facts that this might have been FAP, and so this was a penetrant enough and there were preventive measures enough that this was the case where duty to warn should exist. And so these two cases and in that case, they said that, telling the patient themselves was not necessarily enough, that it might require some contact to the family members as well. So it did expand a little bit beyond the Threkel case that I had talked about. But these cases are interesting because not much has happened in this area of law since the 1990s. And if we think about how much information has been given and this sort of specter of the duty to warn that's talked about in the medical community a lot, it's just interesting to note the lack of cases in this area since then in other jurisdictions. So this is still a fairly open question that I think will at some point be answered more broadly in the law. All right, so turning away from the medical community and medical liability and researcher liability and all that space, let's talk a bit about criminal law. So criminal law and genetics has been in the news quite a bit recently because of the case of the Golden State Killer. This was a serial rapist and murderer in California. It was a cold case. The crimes had happened decades in the past, and they were never able to solve it, although they had DNA from the scene of the crime. And they used that DNA originally to search criminal biobanks, but didn't find any information. And so then they turned and they used public access genealogy databases to try to find family members of this suspect. And eventually, through finding family members, they were able to track the suspect and then directly get his DNA to identify him as their suspect. So those cases are going on right now. Those criminal cases are going on right now. They arrested the man that they found through the genealogy search. But I want to talk a little bit about not so much the genealogy search. That was a publicly available database, and so that's different from a legal perspective than the original criminal biobanks. But I'm going to talk briefly about how even criminal biobanks were able to happen. So criminal biobanks are situations where the police collect DNA from people who are arrested or are convicted of crimes, and then they put that in a biobank, and this can either be at the state level or at the federal level, and then those can be searched whenever there's a DNA at the scene of a crime, and you can try to match DNA at the scene of the crime to people within this biobank. Right? But this wasn't always a guaranteed thing that could happen, right? Because we have the Fourth Amendment that protects against unreasonable searches and seizures. And so the question is it an unreasonable search and seizure for the police to take somebody's saliva and analyze that and put it in a database? So one of the first cases of this, as an example, there's been quite a few in this line of cases, is Jones v. Murray. This was a Fourth Circuit case, and it's an example of a holding that a criminal biobank for convicted felons does not violate the Fourth Amendment right against unreasonable searches and seizures. So this was a case where somebody who was convicted of a felony would have their DNA taken. So that was held to be okay. Right? Then we have a line of cases like Maryland v. King. Maryland v. King was a US Supreme Court case. And this said that collection of DNA after an arrest for a violent crime was constitutional. So in Jones v. Murray, we're talking about convicted felons. In Maryland v. King, we're talking about somebody who's arrested, right? And so it does broaden the range of people who have their DNA collected, and it potentially includes innocent people, because we're innocent until proven guilty, and people can be arrested and not have been convicted of the crime in the end because maybe they didn't do it, right? So Maryland v. King said that's okay. It's still important for identification purposes to gather people's DNA upon arrest. It's similar to fingerprinting, let's say, right? So since then, right, then we start to get into familial searches. And so in some states, familial searches are allowed where the police can use the criminal biobanks to search for partial matches to help identify family members who might have committed the crimes, right? So family members of those already in the system. And this creates some concerns of racial profiling or disparities given our disparate racial problems that we have within these criminal justice system in general. And so the familial searches, are going through, might come up through the court system, and there's questions over whether that violates Fourth Amendment. And then we have the Golden State Killer case, where it's not just looking at the familial searches of the original criminal biobanks, but looking at a broader genealogical search, right? And so we can see this sort of slippery slope where we go from questioning whether just taking DNA from somebody who's convicted, whether that violates the Constitution, that's held to say no, but we're sort of each time broadening the number of people that the police can have access to. And so I would suspect that there would start to be cases about whether or not the police should be able to look at these broader public databases without warrants, right? Just a note that this is federal law, but that state constitutions can create other protections. So State v. Medina is a Vermont Supreme Court case, and this held that it was against the state constitution to collect DNA from those arraigned for a felony. And so the upshot of this is that state constitutions can be more protective than the US Constitution, and the court found that arraignment is sufficiently different than an arrest to differentiate from Maryland v. King. So there can be different rules in different states where it says that the state constitution doesn't allow this collection of DNA, even though the US Constitution would maybe allow it. All right, so on to our fifth and final discussion section about genetic discrimination. So genetic discrimination is when an actor in society uses somebody's genetic information in a negative way, right? So we have the Genetic Information Non-Discrimination Act, or GINA. This is a law that was passed in 2008, and this prohibits covered health insurers and employers from using genetic information to either fire somebody or not consider them for hiring, or in the health insurance arena to charge higher rates or to deny somebody health insurance. So I'm going to talk about two different cases from the employment side of GINA. So there's two different, quote, lines of cases. So lines of cases are, in case law, there's different ways of interpreting the law, right? And so, like I said, courts can sometimes take arguments from other courts to find them persuasive, right? And so if one court interprets a statute one way, other cases can sort of borrow from that and create this line of legal reasoning. And in GINA, we have these two lines of legal reasoning that are forming that are creating a little bit different interpretation of GINA across the country and across jurisdictions. And so the first case in one of the lines of interpretation is called Poor v. Peterbilt. This is a Western District of Virginia case. And the facts of this case are that Poor was an employee of Peterbilt, and he had health insurance through work. And he was asked to complete a medical questionnaire in the course of his work, and he disclosed that his wife had multiple sclerosis. His work asked for more information about that multiple sclerosis diagnosis, and then 3 days later, Poor was fired. And so Poor said, this seems like it's discriminatory that you took this medical information and then used it to fire me, right? So there are other claims that could be involved under disability protections, but just focusing on GINA and the genetic information protections, Poor said, you took my genetic information and you used it to discriminate. So why is he saying that this is his genetic information? Well, GINA classifies a person's family members' manifested conditions as protected genetic information. So the manifested conditions of my family members are my genetic information. And so the question that was presented in front of the court was, does the manifested condition of his wife matter if it was taken into account, right? So does the manifested condition of his wife count as his genetic information? And in this case, the court said no. And the reason was they looked at the predispositional impact of the medical information. And the court said that the wife's multiple sclerosis diagnosis did not have any predictive value for Poor, right? And so because it didn't have any predictive value for Poor, it didn't count as that genetic information and qualified to be brought under GINA. Now, there's been some criticism in the academic realm of this interpretation because GINA itself does not talk about the predictive value of manifested conditions when they're considering the definition of genetic information. And so in some ways, this court narrowed the definition of GINA by narrowing it just to information from family members that has some sort of predictive value. And there have been other cases under GINA across jurisdictions that have interpreted the case law in this way, right? So they've said it matters whether or not that family member's information is predictive for the employee who's bringing the case. On the other hand, we have a case called Lowe v. Atlas. Lowe was the first jury trial to be brought under GINA. And this is a case that is known as the, quote, devious defecator case. And so what happened was there was a warehouse, Atlas, and somebody was defecating in the warehouse. They didn't know who, and they were trying to figure out who it could have been. And so they triangulated when these specimens were found in the warehouse, and they triangulated to a number of different employees who their employee schedule matched when these actions were happening. This is the case that I always get to describe because it's one of the first major cases, and it's of course the fact pattern that's the hardest to explain without just using all sorts of terminology that I shouldn't. So lots of fun for us lawyers. But anyway, so the employers thought, ingenious, we're going to take DNA from these employees and use it to identify whether or not these specimens match, right? So that we can figure out who this devious defecator is. And so Lowe and a couple of other plaintiffs brought a case and said, you violated GINA, right? In the end, the employees were not a match, right? So they weren't fired. No action was taken against them because they weren't the ones that were doing the act. But they still said that this was a violation of GINA because GINA prohibits employers from collecting, requesting, or requiring genetic information. And so they said, you collected our DNA from us for analysis, and just that fact that you collected that information is a violation of GINA. The employer argued that it wasn't a violation because they weren't using the DNA for medical purposes. They were just using it for identification purposes. They were just using it as a type of fingerprint. And the court said, no, the law is very clear that this is just about collecting genetic information. It doesn't talk about any medical predispositions. And so just the fact that you collected it, no matter what the purpose was, is a violation of GINA, or it can be allowed to be viewed as a violation of GINA. It then went to the jury, and the jury said that Atlas was in the wrong, and they issued an initial $2 million award, which was lowered by the court, but their initial thought was this was worth $2 million that these men had to give their DNA to their employers. So you can see the difference between the Poor case and the Lowe case, where Lowe really looks much more expansively at genetic information and collection of genetic information to say just collecting DNA in general violates the law, whereas Poor really narrows down to that medical predisposition side. And so as cases go forward, we can expect that we'll see more coming out with these different lines of cases, one focusing on predispositions and one focusing on privacy and protections more broadly. So that was the whirlwind description of interesting and upcoming or current cases and past cases, of course, in the 5 case law theme areas of ownership of biospecimens and genetic data, liability, focusing on research liability and laboratory liability, duty to warn, criminal law, and genetic discrimination. So I hope that was interesting. And you're free to email me if you have questions, but I encourage you all to keep focused on legal cases as they go forward because they really do affect the genetic counseling perspective and your patient's rights. So thank you so much and have a wonderful day.